If you don't know me, my name is Charter Morris. I'm Director of International Student and Scholar Services. Our office is here to help you, of course, with your student visa questions and to help you as you navigate your degree program. But we also are here to hopefully point you in the directions that will get you set up for success after you graduate. And to that end, I was going to go ahead and turn it over to Carol Armstrong to start our presentation today. As we go through this, if you want, you can put questions in the chat box, and I'll be monitoring that and trying to answer as quickly as I can anything that may come up and hopefully point you to the right direction. But with that, Carol, I'll turn it over to you.
Thank you, Charter. Good morning, everyone, and thank you for attending this presentation. I'm sorry that we can't all be together, but I'm hoping that the information that we discussed today will be helpful to you in planning your future beyond graduation. Want to start out by just maybe talking about some of the services that the university does provide for you, because those are going to be important in our discussion today. And I want to start out by saying the Career Services Office, of course, is also helping sponsor this workshop for you to try to help you understand that, you know, you've got to begin your planning early for life after graduation, particularly for foreign nationals who have to worry about immigration status and employment authorization in order to remain in the United States. I know as you've been working with the International Services Office, you've been able to manage your temporary status, whatever that may be, as well as getting advice for travel and things like that. But one of the aspects of planning for beyond graduation is going to be planning for optional practical training. And that is something that Charter's office will work closely with you in planning and making sure you're meeting the appropriate filing deadlines and answer your questions about that process and how long it lasts and what you need to be doing and when. So that's kind of at the beginning of your journey. You're not graduated yet, but you do have to plan for how you're going to have that continued status and work authorization beyond graduation. So Charter, I know you have pointed them to the university website that gives a lot more detail, but did you generally want to touch on just the very key points about planning early for
Absolutely.
OPT?
So OPT is optional practical training. It is the honestly the best bargain in all of employment authorizations that you can find, because it is a benefit that you have as an F1 student that is pretty much guaranteed. The main caveats here are that you have to file on time. And so your window of filing for optional practical training is you can file up to 90 days prior to your completion date. That completion date is a kind of a hard thing to nail down sometimes, because some of you are graduate students, and so your completion date may be tied more to your dissertation defense, or it may be tied to the timing of the submission of your dissertation or your thesis into the graduate school. But all that being said, as you're approaching that final semester, the semester in which you're going to be submitting your dissertation or your thesis, or if you're an undergraduate student, your last semester you're taking classes prior to graduation, you want to plan to apply as early as 90 days before the end of that semester for OPT. Your window is up to 90 days before and up to 60 days post completion. And so that is your 5-month window, 150-day window. The other considerations are you do have to get recommendation and a new I-20 from our office. So you would actually start this application process with International Student and Scholar Services. We'll work with you to issue the new I-20. We can look over your paperwork before you submit it to U.S. Citizenship and Immigration Services. The final application and approval does come from USCIS, so you would submit that application to them, and then they will make a decision and they will issue you an employment authorization card. The EAD card is typically valid for up to 1 year initially, and those of you who are in STEM recognized fields would be eligible for a possible 2-year extension on that. The other big caveat on this is not so much the timing, is that the work authorization practical training, both the type of practical training you can do towards internships during your degree and like CPT and OPT, it's tied to your major. So it's to get practical training in your field of study. And the hope is that it will set you up well for transition into life after graduation. It will ease that transition into the workplace, whether that is, you know, through a work visa here in the U.S. or even returning home and to get into the job sphere there. So just keep in mind that while you'll get an EAD card that will allow you to work up to a year, possibly 3 years if you're STEM eligible, it does have to be related to your major. So it wouldn't just allow you to work anywhere, but it is a great opportunity. And we know it can be a little bit overwhelming to go through that process. I'm going to link actually directly to the OPT section of our student employment page here. We've got some great information there. You can make appointments with us to ask questions. We're currently working on a new learning module that, unfortunately, our learning module that's linked there is kind of a blank page right now. So we're working on that right now, but we'll be happy to help you walk through that process. And there was actually one question related to this in the chat. Can English Language Institute graduates apply for OPT? Unfortunately, that is not something that the ELI students. So for CPT and OPT, there are restrictions because it has to be tied to your major and to your degree program. With ELI students, they're considered non-degree programs. So anyone here who's here on an exchange with a non-degree program or who's on ELI studies is ineligible to apply for OPT. You can only apply for it after completing an associate's, bachelor's, master's, or doctoral degree program. Anyway, with that, I think I've answered the questions. We do have some other questions, so feel free to drop these into the chat. We may not get to all of the questions in the order that they're submitted. Just be aware that some of these we will hold on to until later in the session when it might be more appropriate. Okay, so with that, I'll be quiet.
Well, Charter, I have a couple of questions that probably you can answer. How much does it cost to get this OPT thing?
Currently, it's not terrible. It's about $410. I think that's the going I-765 rate. I may be wrong on that. I need to double check.
That's right.
So it's actually quite affordable when you compare it to like an H-1B, which could cost an employer thousands of dollars. For $410, you've got a year of work eligibility. It's a bargain. It really is.
I guess the other question that I might have if I were a student would be, can I travel while I have this OPT? Can I still go back and see family?
So because you're an attorney, I'll answer in an attorney way. It depends. No, it's absolutely. It is while you're on OPT. A lot of people think of OPT, unfortunately, they get the idea that it is its own visa. Actually, while you're on OPT, you're still on an F1 visa. So your I-20 controls your ability to stay in the US and to travel. And we have many students who are able to travel pretty easily. The only caveat that I have or one major caveat is, if you're going through the green card process, which we will discuss here, just keep in mind that might be in conflict with your F1 non-immigrant status. So we don't recommend traveling while on OPT if you started the green card process. There's a different form of travel authorization that comes with that. But yes, while on F1 OPT, it is possible to travel. I mean, again, STEM OPT eligible students can be on OPT for up to 3 years, and the only thing that they need to be kind of planning around is making sure they get a travel signature on their I-20. Travel signatures are only valid for about 6 months at a time when you're on OPT, rather than the normal 1 year at a time. And it leads me, I remember one other thing that I was going to try to tell you about the timing of OPT applications. I know I talked about the 90 days prior and up to 60 days after completion. One other thing is about the timing it takes for OPT to process. Employment authorization documents all use the form I-765. And as Carol's well aware, I-765s are used for like dozens and dozens of types of applications. So green card applicants can file an I-765 for work authorization. H-4 dependents can file for work authorization using the I-765. So there's a lot of different categories that could potentially use that same form. And so for OPT applicants, the question we get a lot is, how long does it take to process the I-765? And you need to be aware that it's different for all different application types. So if you just ask randomly, you know, how long does it take to process an I-765? Well, for an applicant for an H-4 EAD card, it might be 7 or 8 months. For F1 OPT, it's going to be hopefully significantly shorter. Our current processing times are between 2 and 3 months once it's filed with USCIS, which is fantastic. Actually, it's the fastest of the I-765 processing that I'm aware of, outside of like special cases like our, you know, like refugees or asylees or something like that. So just be aware, you know, even though you have a window of time to apply, it's still going to take time for USCIS to process your application. So if you wait till the last minute to apply, add 2 months to 3 months before you actually get your EAD card. You know.
Well, Charter, I've heard some of my friends talk about I can pay like an extra premium processing or something like that. Can I do that to get my OPT faster, where I don't have to, you know, worry about the timing?
That would be wonderful. In fact, there's discussions about that. The premium processing, they are slowly rolling out premium processing options towards other application types. In the past, it was limited to employment visa types like H-1Bs, filed with an I-129. And I know we're going to talk a little bit about that. And they've expanded it to include more green card types that weren't included before, which is fantastic, because that has been one of the most requested things that I've seen. And we're starting to see it for changes of status applications, I-539s. At least that's the discussion. It was supposed to roll out this month. I have not seen it approved yet. I haven't seen a timeline for that from USCIS. But I don't believe I-765s have been added to the expedited processing list yet. Carol, have they, or?
No, like same thing. There's been discussions about it and proposed regulations and that sort of thing. But to this point, we're not going to have that option. So as Charter mentioned, I mean, you really do have to plan ahead, and don't wait until after graduation to start this process, because if you find a job, and I don't know if Tanya in Career Services office may want to offer her insight on this, but if you find a job, that employer is going to be expecting you to start, you know, at least by the time or shortly after graduation. And if you are still sitting around waiting another 3, 4, maybe 5 months, depending on processing times, to get your work authorization, you may lose that opportunity. And so that's something that you really got to be cognizant of. Although, you know, we're talking about laws and, things that you have to do to file to get your work authorization and status. What you really have to focus on is, am I planning for my future in a way that's going to be most effective for me to gain that experience that I need and be able to go to work for that employer so that I can show them my skill set, show them how great I am, and perhaps they'll want to sponsor me for one of these other types of immigration status that we're going to talk about in a little while. Tanya, did you have anything to add on that?
No, Carol, you covered it all. That is 100% correct.
Okay, so if you want to advance the slides up to the next one, let's talk a little bit about what happens after OPT. And so this is just kind of a big picture that we're focusing on this planning theme. OPT won't last forever. You may have a year, you may have 3 if you're in one of the STEM identified fields. So depending on which of those time frames you have, the younger you are, the more you think that a year is a really long time and that 3 years is a really long time, but it's really not that long of a time once you start working and facing, all the obstacles that come along with the planning for that. So we have to think beyond the F1 status. We have to think beyond the OPT. What are going to be my options then? And there are various options that are available to you. And we're going to talk about temporary options. And then we're going to talk about some more permanent options through permanent residency. You may hear me say permanent residency. You may hear me say green card. I'm referring to the same thing. If you're a permanent resident, you get a green card, which is a permanent resident card. And they actually are green again. For years, they weren't green, and now they are green again. So one of the most common employment sponsored or employer sponsored categories for graduates are going to be the H-1B. And the H-1B is available for specialty occupations. And the specialty occupations are jobs that normally require at least a bachelor's degree or equivalent in a specialized field of study. And so a specialized field of study is going to be, for example, if I have a bachelor's degree in English, I'm not going to be able to go out and do an accountant's job, okay? Because accounting is such a specialized field of study that I need to have an accounting degree to be able to do it. I'm probably not going to be a financial planner either if I have a degree in, I don't know, fill in the blank, social sciences. Just because those are specialized fields of study, you can't have an English degree and become a mechanical engineer. You just don't have the background knowledge to be able to perform even an entry-level position. So that's what is indicated with the specialized field of study. Now, just because you have a degree, a bachelor's degree or higher in mechanical engineering, that does not what qualifies you for the H-1B. That is one component of it, but the job itself must actually require that degree or a very strongly related field. And the Immigration Service is going to evaluate that along with the U.S. Department of Labor to make sure that that position normally would require this specialized degree or this specific degree in order for you to perform the position. So, you're going to have various types of jobs out there. You got to be sure that when you're seeking employment and thinking about some of these things, you may want to be thinking about the type of job that you're taking. For example, if you are taking on an assistant management type position or something like that, and it requires a general bachelor's degree in business administration, that may not be a position that's going to qualify you for an H-1B when your OPT runs out. So you got to be conscious of those factors in trying to determine whether or not this position is going to lead you to the possibility of remaining or changing your status to H-1B once your OPT runs out. Now, with the H-1B, it is employer sponsored. So keep in mind that, goes back to when you're looking at potential employers, are those potential employers going to be willing to sponsor you for something beyond your OPT? And, probably Tanya in the Career Services Office, you guys probably are familiar enough with some of the employers to know whether they are immigration friendly or at least immigration cognizant, as opposed to, to not being friendly for that. So that may be something that the Career Services Office may be able to help guide you. But again, it may be a conversation that you're going to need to have, early on in your employment, or at least before you even accept an offer of employment, to determine whether or not this employer is going to be willing to sponsor you once your OPT runs out. And if not, hey, maybe you gain a year of experience and you go to work somewhere else and find another employer. That may be an option. And certainly, a lot of employers prefer to get someone who has at least a little bit of experience. So that is not, that's not the end of the world, but it is something that you need to be cognizant of to kind of find out, okay, is this just going to be a 1 year or 3 year gig, or is this something that I'm going to get sponsorship on and they're going to, I'm going to be able to remain in this position for a longer period of time. If you do find that employer, one of the things that will be important for determining whether or not you can apply for an H-1B is this cap on the number of H-1Bs that are available each fiscal year. The fiscal year begins on October 1. That's the government's fiscal year. So that's when the hiring date begins, October 1 through September 30. And employers start applying for that as early as early March and trying to, secure one of those H-1B numbers. There's only 85,000 per year, and 20,000 of those are just for U.S. master's degree folks. So if you have a U.S. master's degree, then you could apply in that particular, for those 20,000. If you don't get in that, then you apply for the other 65,000. The problem with it is, in the last several years, the cap has been met pretty quickly. And the reason for that is there are, 85,000 available. They are getting anywhere from 225, 240 to 300,000 applications per year. So that is a big issue. And that is something, if you've got an employer who is subject to that annual cap, and not all employers are, but if your employer is subject to that cap, you've got to start the process of applying to change your status to H-1B as early as March for a start date that's not even going to carry through or won't start until October the 1st. So I have 2 questions for Charter. And one of those is, do you happen to know any employers just off the top of your head who might be, or types of employers who might be cap exempt? And then the other question I have is, okay, if I get this H-1B and my OPT runs out, let's say June the 1st, but I don't have employment authorization until October the 1st, am I going to have to leave the U.S.? Am I going to lose that job?
No, these are great questions. And honestly, the answers are much better now than they used to be. Many decades ago, the universities like us would have to fight with private sector employers for the same cap of employment numbers for the H-1Bs. And so it would be this big struggle. And of course, schools don't run October 1 to September 30th. They run usually in August or starting in September. So we are what's called cap exempt now. So, a few decades ago, it was recognized that higher education institutions could never meet those same restrictions that the private employment sector could. And so we are cap exempt. So if you are, especially graduate students here, who are looking at possible academic tracks. Maybe you're looking into going into research, or you're looking to go into teaching. Making that transition to an H-1B through a university employer is always a possibility. And keep in mind, it's university broadly speaking. So a university to qualify as a CAP exempt employer only has to be a higher education institution. It doesn't mean that they have to be a public university. Private universities are included in this, for-profit universities and nonprofit universities. As long as they're a higher education institution and they're seeking employment, they're not subject to the cap, and it's not restricted to just teaching positions. It's also staff positions. So at the University of Alabama, I have roughly 100 H-1B holders right now. So we sponsor their H-1Bs. We do the extension process. We work with the departments and the faculty and staff to process that. Now, is it the easiest process? No, but we're here to do that. We do it regularly, and we have great experience with that. And you're going to find a lot of universities, even small institutions, will be able to work with you on that. Now, smaller institutions may not have in-house processing like our institution does. They may have to work with a firm like Carroll Armstrong's in order to process that. In fact, Armstrong Law does work for other universities for the H-1B filings. So it's not uncommon that universities or colleges turn to immigration attorneys or immigration counsel to handle that process, but they're still CAP exempt, meaning they're not stuck with that quota that opens up in April and only starts in October. Now, the other question was, what happens if you do have an H-1B sponsorship, but you're in a CAP subject field and working for a CAP subject employer, and so you're one of those that were lucky to get sponsored for an October 1 start date, but your OPT ends in June. Well, that's something else that was addressed in the last probably 10, maybe 15 years. I'm trying to remember, I can't remember exactly when the CAP gap was really addressed, but it was a very common thing. So most academic programs run, say, August to May, or maybe September to June, right? And because OPT has to start within 60 days of your graduation, you have your OPT starting between May and maybe August, and at the latest, if you're a June graduate. And because of that, it means that a year later, your OPT would be running out. And if you were the beneficiary of an H-1B in the for a CAP subject employer, that H-1B begins on October 1. And so very obviously you have a gap between when your OPT ends in May, June, July, August, and when your H-1B begins in October. And there was a dark time where it meant like, well, too bad, you've got to leave for a little while and then you can come back on your H-1B. But that was all addressed, and now there's something called a CAP gap OPT extension that's allowed to be applied, and it's supposed to be done automatically. And what that means is that if you have a 1-year OPT, or if you have a 3-year STEM OPT, and you're the beneficiary of a timely filed H-1B that is CAP subject for a change of status, it has to be specifically changing your F1 to an H-1B status here in the US, then if you have OPT that ends anytime between April 1 and October 1, when that H-1B is supposed to start, you'll get an automatic extension of your OPT through September 30th, so that it covers you all the way up to the date that your H-1B begins. And it was a wonderful solution to a long-standing problem that early on in my career we had to deal with quite a bit. Now, the way it's handled has been has changed over the years. It's always been supposed to be automatic, but honestly, it's been a little convoluted. I'm actually not that anybody needs it right now, because nobody here has applied for OPT yet, but we have a section within our OPT information about the CAP gap and about the scenarios in which you would get that automatic extension. And most of the time when students reach out to us, and say, hey, my employer filed an H-1B and it's been approved. Can I get my cap gap I-20? We just go into CVIS and it's ready to be printed. We don't have to do anything. But sometimes we have to get, documentation about the H-1B filing and get a data correction with USCIS and SCDP. And then we update your I-20 with that cap gap notation on it. But it is a lovely scenario that covers that gap that will inevitably happen if you are a spring semester graduate. Now, for those of you who are summer graduates or winter graduates, this may never be an issue, but it could be something that will help the vast majority of you.
Thanks, Jordan. That was exactly what my question was, or the answer to my question. So we didn't really get into a whole lot of detail about what employers are cap exempt and which ones are cap subject. So the easy answer is an employer is subject to the cap unless they are exempt from the cap. Okay. But those who are exempt from the cap include, as he mentioned, a higher education institution. And then you've got some governmental research organizations. You've got, those employers who may be affiliated with one of those. And there are some other smaller areas that are exempt from the cap. So you can get more information about that at uscis.gov and just look up their H-1B page. And it'll give you information about the types of employers who are likely going to be cap exempt. The other thing that I would throw out, particularly about the cap subject employers and even some cap exempt employers, sometimes your smaller employers are not as familiar with what all this OPT and H-1B and green card and all of that, what all of that means. They just want to know that if they put your information in E-Verify, that you're going to come back and show that you've got proper work authorization in the United States. So it may be that, you're going to need to, when you have those discussions with a potential employer or, a current employer, it may be that you're going to have to, be prepared to explain some general information. So you may want to seek some counsel yourself or, do some research on your own to have a basic understanding of, what all of that means. Typically, your employers who are filing for H-1Bs for you, they're either going to have in-house person who does the H-1B processing, like Charter mentioned at UA. They handle those in-house, or the employer is going to need to have an immigration attorney to assist them with, going through that H-1B processing. So you just need to understand that it is an option for you. And, for graduates, it can be, an easy immigration fix, if you will, for OPT, if you find the right employer. But again, that's one of those things that you need to be planning ahead. And particularly if you're going to be working with a cap subject employer, with cap subject employers, that initial registration starts in March for a position that's going to have a start date of October the 1st. And, it may turn out that after the cap lottery, which is basically they've got 300,000 registrations and only 85,000 H-1Bs available. So there are, a lot of folks who don't get selected to then apply for the H-1Bs. So if you've got 3 years of OPT, I would encourage you to go ahead and start that. If you're working for a cap subject employer, go ahead and get in the H-1B registration the very first opportunity, because if you don't, you may not be selected, and then that option is no longer available to you if you're working with a cap subject employer. The good news is with cap exempt employers, they don't have to worry about all that registration. They don't have to worry all about the cap lottery. They just decide, the employer decides to hire you and to sponsor you, and they file the H-1B petition, and you can have your start date to start whenever your OPT expires, or even earlier if there's a reason to do that. So that's another big piece of the planning ahead, just making sure that you're thinking about some of those options and understanding those so that, you know, if you've got an employer who doesn't understand some of the obstacles that, you know, folks will face with immigration status and work authorization, just so you can, you know, be generally prepared to explain that to them. Or maybe encourage them to, you know, to talk to a lawyer to get an understanding, or even somebody like an international advisor's office who can give them a little bit of information on what all is entailed. Now, the H-1Bs are employer specific, job specific, and location specific. So if you get an H-1B for, let's say, company A, who is a cap subject employer, and you know, let's say for some reason they shut down, or you or the employer decide this is just not working out, which happens sometimes. If you want to go to work for company B will have to sponsor you and file an H-1B petition for you. However, you won't be subject to the cap again, because once you're counted, you're counted. That is up to a 6-year limit. In other words, you can get a total of 6 years in H-1B status. That's usually broken down into 2 3-year terms that you're approved for. And then that's it. And you have to leave the United States for a year, and then you can come back in and do another round of 6 years in H-1B status. Unless you timely start the permanent residency process, which we're going to talk about a little bit more. So again, it goes into that advanced planning. Even if you get the H-1B, you've got to think about, okay, well, I'm only going to have this for a total of 6 years. And most employers are not happy if you have to leave for a year, and they're going to have to do without your services for a year before you can come back and apply for another H-1B. So that's just something to be thinking about. There are some other types of temporary status, but Charter, did you have anything else you wanted to touch on, or Tanya, with the OPT and H-1B?
You know, I think you've hit on the big things, just knowing that if you are STEM OPT eligible and you've got those 3 years, it gives you basically 3 cycles of the H-1B selection process for if you get on with a private employer. One of the primary benefits of OPT, and you touched on this too, like what happens when you and your employer aren't necessarily getting along very well. OPT gives you the flexibility to jump to another employer without any kind of sponsorship issues whatsoever. So it is a really good benefit. In fact, it's not impossible for somebody on OPT to hold multiple jobs at the same time, whereas H-1Bs, because it's very employment and employer specific. H-1B is not a blanket work authorization. So any change in your employment, any change in employers, any change in location requires additional filings of the H-1B. So it is a very beneficial visa type because it does allow for a smoother transition to other things in a more permanent fashion. But it is a little bit more restrictive in how it can be used. So, but yeah, that's the only thing that I would add. And I don't know if I said that we touch on this later. You mentioned other work visa types. We have one of our student athletes in here, and he was even asking, like, hey, what if I want to continue my athletics afterwards? I don't know if we touch on like P visas or O visas later on in this, do we?
Yeah, I kind of generally go through those, but we can jump to those if you guys want to go there, and then
well, we
talk
can
about some of the other temporary options.
We can hold off on those until a little bit later.
Okay.
if we want to move forward. I know we've got a lot to cover. So,
okay. Tanya, do you have anything else from your office?
I just dropped it into the chat. The only thing that I would have added is on our application system Handshake, where jobs are listed and internships are listed, there is a search feature where students can look specifically for OPT and CPT employers who are willing to hire those international students.
Excellent, thank you. All right, if you could advance a couple of slides to the other temporary options. There we go. Okay, all right, so you'll notice with these temporary types of status, they're all letters of the alphabet, so we generally call that the alphabet soup of immigration. There are some that specifically I think might be applicable to some of you. If you are if you are from Mexico or Canada, the TN, which is we call the NAFTA visa, or now it's USMCA, or so I'm not even sure what it's called anymore other than the TN. Professional positions, which are typically those that require a bachelor's degree or higher, those positions may qualify for a TN. And that basically, you go to a port of entry and apply for that. You know, they're at the, you know, at the port of entry with all the documentation proving that the position qualifies for the TN. The employer support letter would be there that explains all of that. An offer letter, your credentials, just to show that you actually have the required degree, experience, credentials, that sort of thing. So that is an option for Mexico or Canada. There are also some others. Usually the treaty trader and treaty investor type of visas, the E's, those are going to be if you are a national, a citizen or national of the treaty country, and if the company is owned by, you know, individuals, nationals of that company, and it's in particular types of positions, and those usually require a great deal of trade and investment, then it may be that that's an option for you. Again, that's a little more detailed than we'll get into here, but just that is a possibility. Those can be those positions can be anything from, you know, working in manufacturing, IT, all sorts of different types of positions that would qualify there. It all comes down to whether there's a treaty in place for the country, whether that company is owned by individuals and nationals from that country, and whether or not, you know, there's sufficient trade, sufficient investment. So that's one option that may be possible for some. There's also an L for intra-company transferees. Typically, if you're just graduating, that's not going to really be an option. But if you were to go to work for a company abroad, and they have operations there and in the US, and you're in some sort of specialized knowledge or managerial or executive role with that company, then it may be the company may need to bring you back to the United States, and that L intra-company transferee visa may be an option for you as well. Probably I know we had a question about the P's and the O's. For the P's for athletes is an option if you're going to be continuing to perform in the United States, then that may be an option for you. There's also the O, which is going to be for exceptional ability. And that can be in various types of expertise or skill. It can be in different types of fields, business, the arts. But you do have to demonstrate, you know, a higher level of accomplishment for the O than you would just, you know, an H-1B or a TN. Those are the main ones that I wanted to cover as far as business related and academic related. Is there anything else in particular that we've got in the chat box there or the question box that anyone has asked specifically about?
No, there's some stuff that's going to touch on the green card later on. So I think I'm holding off on that, but I think we've touched on everything that we've had in the chat so far.
Okay. Maybe that next slide. I also want to just point you in the direction of sometimes there's, you know, you may be familiar with the B visa, which is just the visitor visa. A lot of times you may be caught in a situation where you're trying to decide, are you going to, you know, advance to another degree field, or I'm sorry, a degree level, or are you going to try to find employment? Sometimes you may be able to change to a B status to be able to buy some time, but keep in mind that does not give you the right to attend school. That does not give you the right to work in the United States, but it can be I guess a stopgap measure to try to help you in those situations. And then the other thing I always try to touch on anytime I have a workshop is just to make sure that you understand if you have ever been a victim of a crime. There is a special type of status for victims of certain types of qualifying criminal activity that occurred here in the United States. If you have reported it and cooperated with law enforcement, there are some special types of status there that may put you in a position, to obtain work authorization and even have an option at permanent residency in the future. Again, if you haven't been, either you qualify for it or you don't, but it is an option that's out there and available. So all of these options that we've been talking about, and you'll do the next slide, are, temporary status. If you're in H-1B status, we talked about how that's going to run out at some point. A TN, you're going to have to keep traveling back and forth and getting that renewed. Ls have a finite, life to them. O's, you've got to continue to maintain your itinerary for those to be able to maintain the O. So all of these can be problematic as far as a long-term plan. And indeed, none of them are really a long-term plan. Now, you may be able to get, several years in some of the various types of status, but you need to understand that at some point you need to be thinking about permanent residency. And so there are really 3 tracks to permanent residency, and those are protection-based, family-based, and employment-based. We're not going to spend a lot of time talking about family or protection-based. We're going to spend most of our time talking about the employment-based. So if you are remaining in the US, let's say you get your OPT, and then maybe you were fortunate enough that you either went to work for a CAP exempt H-1B employer, or you were lucky enough to get selected in the H-1B CAP lottery, and you are now working with your employer and decide that you want to seek, permanent residency in the United States. What are your options? Let's talk about some of those. Next slide, please. One of the most common types of employment-based permanent residency are those where the employer is required to go through a process called labor certification. Labor certification is basically a type of process that is driven by the U.S. Department of Labor, and it's basically designed to protect U.S. jobs for U.S. workers. That's the whole intent of going through labor certification. So there are various types of labor certification. There's traditional recruitment, and then there's a special type of processing for university teaching positions. So we're going to talk about both of those. If you are not in a university teaching position and you go through the labor certification process, you're generally going to be going through the process called traditional recruitment. This basic recruitment process basically requires the employer to conduct a search. It's a test of the labor market. So they will go and they will place ads and they'll post notices and they'll place positions with the state employment office and in the newspaper and try to find a qualified U.S. worker. And it's a qualified U.S. worker who can meet the minimum requirements for the position, whatever they may be. And with that test of the labor market, if even one minimally qualified U.S. worker applies for the position and is willing to accept it at the location and salary offered, then the employer cannot use that recruitment to support labor certification. So typically when an employer contacts an attorney to say, hey, I think we want to sponsor this person for permanent residency, and we look at the various options and we look at it and say, okay, traditional recruitment may be the only possible way to get permanent residency for this individual. You typically got to look at your labor market and see what are the odds that a qualified U.S. worker are going to apply. And sometimes we don't know. Sometimes it may be that the employer has tried to, to locate and gone through a recruitment process to try to locate other workers in that same position and has not been successful. Maybe there are times where they've had dozens of applications or more from U.S. workers. So, it's really a case-by-case situation where we have to just look at it, and the employer just has to do the test of the labor market. If the test of the labor market is successful, in other words, there's no qualified U.S. worker who applies, then the employer may use that recruitment process to support an application for labor certification for your job. Again, there's a requirement that, the minimum requirements for the position are normal. They're not just tailored to you and what accomplishments you have. And the employer also has to pay the prevailing wage for that particular job in that particular location. So it's cumbersome. A lot of employers get scared away if they're not savvy to immigration to some degree and don't know what to expect. That basic recruitment process can be daunting. There's another process, and just so you know, traditional recruitment, that can apply with any type of employer. You remember how we talked about with H-1Bs, we got cap exempt and cap subject. That's not a factor in any of this. Remember, all of that was for a temporary H-1B. Now we're looking at permanent offers of employment and permanent residency processing. So the stakes are different and the rules are different. And so if with traditional recruitment, you're going to have your private employers who may have to go through this process, and then universities and other types of employers who might have been exempt from the cap, their positions may also be subject to going through this basic recruitment process. Unless the university position is a teaching position. The teaching position for labor certification purposes does streamline the process considerably. Whereas with the traditional recruitment, the employer has to go out and conduct all this new recruitment. And if even one minimally qualified U.S. worker applies, it's over. With the special processing for teaching positions at universities, the good news is the university is able to use the recruitment that it actually conducted in the initial hiring process, subject to a few caveats. And then they also are able to go through with that recruitment. If they identify you as the most qualified candidate over all the U.S. workers who applied, then the universities would be able to sponsor you for labor certification. Remember, with this particular process, labor certification is just the very first step. And if that is successful and approved, then we go to U.S. Citizenship and Immigration Services, USCIS, for the final two steps in the process, which are an employer petition and then an application to adjust your status to that of a permanent resident. So when we get to those stages, it becomes very important to understand that there can be some travel issues that you want to look at. You'll want to talk with your attorney to make sure that if you are in a temporary status like a TN or an F or an O, those will put you in a position where once you file those, you're not going to be able to travel or extend any of those temporary types of status. The H-1B does have some special rules that allow for you to complete your permanent residency processing and still remain in H-1B status with no travel implications or employment implications. But that is not the case for every single type of temporary status. So that's something that's important for you to remember. All right. We have any questions so far about any of this? We've got some other types of employment-based processing that I also want to touch on.
I think actually the only question that we've got that's been unanswered is about the NIW that we're about to talk about. So,
okay. All right. Sounds great. All right. So the next slide. All right. So national interest waiver. That particular category can be self-petitioned. In other words, the labor certification that we were just talking about and a couple of others that we're going to talk about all require an employer to govern that process. In other words, the employer has to be willing to sponsor you. There are certain components of it that the employer must be willing to pay for. And so that sometimes is not an option. There are also types of positions that do not qualify for labor certification, special handling, or other types of processing because they are not considered permanent positions. And in order to apply for labor certification or some of the other types of positions types of processing we're going to talk about, you've got to be able to have what's considered a permanent position. So in your experience, Charter, working with academia, what is a type of position that wouldn't qualify for labor certification, but that might be a good possibility for a national interest waiver?
Without a doubt, the one that we have the hardest time with is postdoc positions, because their very nature is temporary. So we can't say that it's a permanent position. And so we run into a real trouble trying to sponsor a postdoc for permanent residency. But quite often they could qualify through the NIW route.
And the NIW category, just some recent developments under the current administration. Basically, your STEM applicants now have a much greater shot at these, because the STEM applicants, the fact that it is a STEM field is being given a lot more weight in connection with the NIW filings now. So there have been changes over the year for this process, but that's probably one of the more significant ones that I've seen. Although a lot of NIW may actually come out of the STEM fields, that is something that is specifically addressed as a very positive factor in connection with the national interest waiver. The name national interest waiver just means that the government is willing to waive the requirement for labor certification, because the applicant's contributions to the United States are so much in the national interest, the U.S. national interest, that it's in the U.S.'s best interest to waive that labor certification and to allow you to just go forward and apply directly for the permanent residency process. So if you're applying for a national interest waiver, you're not going to go through labor certification because it's not required. You've got to show that your proposed endeavor, if you will, which is what you plan to do to substantiate why you should have permanent residency in the United States, it's got to have merit, substantial merit, and national importance. Okay. That is really where the whole STEM field argument has come in, is, we really need to focus on advancing the development of STEM graduates here in the United States instead of losing them to other countries because of, the national importance of, at this point, in, things like engineering and aerospace and physics and some of those fields. That we've got to, our world now is not just the earth, but the world now is, there's space and all the development in space and that sort of thing. And so that's where, it's not just that, it's the different types of technology and engineering endeavors that have really been impacted by these changes for STEM applicants who are in STEM fields. So that's where that national importance is really affected by that change. You've also got to show that you're well positioned to advance this proposed endeavor. What have you done thus far? What is it that you can show? Yes, this is not just an idea I have in my head about what I, theoretically would like to do. This is something I've been working on for years. I have this, I was co-PI on this grant. I've written all these articles and I've been teaching at all these conferences and a variety of other things that you can demonstrate to show that you're well positioned. And you've also got to show that there's a continued need for you to continue to advance a proposed endeavor. And that can come into, different types of medical research. I mean, all sorts of types of research that can qualify for this national interest waiver. And then on balance, it would be beneficial to the U.S. to waive labor certification. Perhaps you're already in that position as a researcher and you found some crucial finding and you're needed to stay there to continue that work. Perhaps your employers and other agencies, federal agencies, are willing to say, hey, we need this person. We don't need to go out and, spend 3-6 months going through recruitment to find someone that we've then got to is going to have to be brought up to speed. We need this person. So that's, just kind of the big picture on the national interest waiver. One of the things, like I say, with national importance, the future impact of what you're doing and how you've been already doing these things, your past accomplishments. So typically when you're going in to see an attorney to be evaluated to see if you qualify for a national interest waiver, the first thing they're going to ask you for is your CV. They're going to want to see, what have you done? And then they're probably going to say, okay, summarize for me what it is that you do, what your work is, what it is that you want to continue to do in the United States. And they'll probably say something like I do, is put it in practical terms that, let's say, a really smart senior in high school could understand. And although the immigration adjudicators and officers at USCIS, we hope that they're smarter than just a smart senior in high school, I always say, let's dumb it down, because I may not understand anything relevant to physics. So you may have to bring it down, several notches for me to understand kind of the foundation of how we got to what it is that the work and why the work that you're doing right now is so significant. Period. A lot of people say, well, how many grants do I need? What's the amount of the research funding? How many articles do I need to have published? How many review articles do I need to have reviewed? All of those things are important, but this is a very subjective category. It is not objective like labor certification. Basically, with labor certification and that particular process, there's a checklist of things that you have to do and the time frames in which you have to do them. If you do those things, you check those boxes, you're going to be approved. Okay, generally speaking. With the national interest waiver, every case is different, and that's what I tell folks when they'll come to me and say, well, my colleague got approved for a national interest waiver and I'm exactly the same as her. Well, no, none of us are exactly alike. Even twins are different, so we're all different, and there are different things that our strengths are different in different ways. Although our research fields may be comparable, we all have different strengths and different ideas about what's going to make our research field better. And so that's the key to understand, is just because a colleague may have gotten approved for this, don't just automatically assume that you will. You very well may, but try to understand that this is highly subjective, and the immigration officer that reviews these cases, they're going to be reviewing them on a case-by-case basis. Do they have a general outline of things that they're looking for? Yes, but your strength may be more in the amount of research funding and the nature of the agencies that have been interested in, this one particular piece of your work. And maybe you've only written 2 articles about it. And maybe, a colleague over here may have written 20 articles, but no major agencies are interested in his work at this time. So it's I don't want to call it weighing, but it is, that officer is going to weigh all of that in considering whether or not you meet that national interest waiver test. Anybody have any questions about that? Or Charter, do you have any additional insight on that particular category you want to share?
I don't have any particular insight, but I know you touched on it earlier about maintaining underlying visa status. I do want to stress one of the things about the NIW is it is extremely subjective. And so my caution to anybody going through the green card process, whether it's marriage-based, employment-based, if it's based off of your personal qualifications, is to, for as long as possible, maintain your underlying visa status. And so that you have something to fall back onto if for any reason anything is rejected. My worst scenario many years ago, we had a postdoc who did file NIW, and she was on our H-1B, and she decided she didn't want her H-1B extended because she already got her work authorization on the basis of her pending PR case. So she concurrently filed everything. So she filed the NIW, I-140, she filed the I-485, she filed for her work authorization. Her family did the same thing. And so she just abandoned her H-1B. And at the time, the department chair, trying to save a few dollars, said, that's great that we don't have to pay this fee for the H-1B. And as the employer, and I do have to represent the employer in these scenarios, I advocate for our students, I advocate for our faculty, but I'm also looking out for the people who pay for our building and our staff and our, the ones that give me my paycheck. And I'm like, no, that's a really bad idea. We need to do this extension. The department insisted that they were going to listen to the postdoc and not do the H-1B extension. So they didn't. Unfortunately, the NIW case that she filed was rejected, and everything attached to it was also rejected because it was all tied together. So her employment authorization that was based on the I-485 that she filed with the I-140 for a national interest waiver, it all fell apart, and she didn't have an H-1B. She had to depart the US. It took her 4 months to get back with her new H-1B because we had to do an emergency filing and had to get her a visa appointment. And she had to go through administrative processing because it was a STEM field. It was a nightmare for the employer, for the employee. She had a spouse and a child with her. They were also impacted by this. I should have been more adamant at the time about the H-1B extension. This was right after I started working here. So it is my cautionary tale always, like maintain that underlying visa status. It might cost a few $100s more to extend something. It may cost your employer a little bit of money, but in the end, it's about safety. It's safety for the individual, it's safety for the employer, it's safety for everybody. So that being said, and that would apply to any of these visa types, not just the national interest waiver. But with the subjectivity of this, it's really up to an adjudicator, and you don't know who's looking over this case. And while they have the guidelines they're all supposed to follow, they may not be convinced by your argument that you are in the national interest, whereas a different adjudicator might be convinced by that. So I don't know. I don't like leaving things to chance. So.
Excellent point, Charter, because that is so important. Maintaining your underlying status is extremely important. Making sure that you get advice about travel during the pendency of permanent residency processing, because there are certain steps in the process where you may get turned back on and not allowed to come back into the United States, or you may be stuck, trying to obtain a new visa stamp, for example, and there are backlogs, and then, you can't get back to your employment. You wind up losing your job. So you got to really be cognizant of those sorts of things. So always, it's better to seek advice through your advisor, through your lawyer, than to just assume that you understand, because there's not necessarily a lot of common sense involved in some of these quirky rules in immigration. And it just, although it may seem that it'll be okay, you got to be really cognizant that it may not. And I agree with what Charter said as far as planning. I always advise folks when they're filing in a subjective category I always tell them, to the extent it's possible, let's see if we can get the subjective part of this petition approved before we go on to the parts that, wind up completing the case. And let's make sure that we keep your underlying status intact so that if this thing is not approved, we don't have an issue with trying to get you back into, some sort of temporary status. So that's an excellent point. If there are no other questions, let's talk about the outstanding professor researcher category, which is also one of those subjective categories. Obviously, this is going to be the type of, it may take you a few years in the field to get to where you can qualify as an outstanding professor or researcher, because first of all, you got to have 3 years of experience in teaching or research in the particular area. There are some situations where we can count your research experience that you gained prior to getting your advanced degree, but that becomes a little bit more difficult case because you've got to prove that that particular research has been recognized as outstanding in the field. If you're trying to get experience for teaching, you've got to show that you had full responsibility for the class taught. So a teaching assistant position is not going to be experience that's going to qualify in most cases. You've got to have a position that's either a tenure or tenure track teaching position or a comparable research position. And many universities, for example, obviously are going to have the tenure and tenure track positions, but there may also be some comparable research positions. Charter, you may want to speak to that a little bit about the types of positions that are funded that may qualify for this. It's not going to be a limited term researcher position. It's not going to be a postdoc.
It's going to be something that's a permanent line, basically. Yeah. So a lot of times here at the University of Alabama, I've worked at 3 major research institutions here in the US, and they typically have postdoc positions, which are by definition 2 to 3 year appointments. And then as they enter year 3, if they're keeping them on as a research, they recategorize them or reclassify the position that the person holds from a postdoc to something like a research associate or senior research scientist, or the titles differ depending on which institution you're at, but it goes into more of a permanent funded position. Now it may not strictly be on state funding, but it has the expectation that it is continual and that it will have it will not be temporary. And so those types of positions we regularly sponsor for permanent residency. We've had quite a number that we've done over the years.
Okay, next slide, please. We talked about how these to qualify for this particular category, the main thing that you've got to show is that you've been recognized internationally as outstanding in a specific academic field. And this is one of those subjective categories. Again, there are criteria that the officer will look at, and those are listed there: the major prizes and awards, membership in an association that requires outstanding achievement, your own published work, published material written by others about your work, original scientific research, your participation as a judge of the work of other people, and that could be reviewing for a journal, for example. So those are the criteria that the officer is going to look at and that you're going to need to include in your petition. And you must have evidence in your petition that you made at least 2 of those criteria. However, when I'm evaluating a CV, I generally want to look at it and say, can we meet 3? Do we feel like we're certain we can meet 3 and that those 3 are really strong? Because with it being subjective, again, it's just one of those things that you've got to be prepared that you want to be meet as many of those criteria as you can. And you got to be particularly able to demonstrate that has international impact. So, if you can't demonstrate that you've had citations from others outside the United States, or you can't get peer support letters from folks other than just people in the US, and it's confined to studies that have only impacted Alabama, for example, that's not going to qualify as international impact. So we don't want to put anything in there that's considered weak evidence. For example, receipt of major prizes or awards for outstanding achievement. Well, I got the best paper award in this class, and I got a certificate of attendance to an international conference. Well, those are not major prizes and awards. It's got to be a national or international level award. And, travel grants and things like that, they're not going to qualify. So we don't want to put any of that in your case, because it's weak evidence and it actually counts against you. So have someone, when, if you get to the point where you think that that you may qualify in this category, if you've got an employer who's willing to sponsor you, you have the experience, and you have the position that qualifies, the tenure track or a comparable research position, then it may be that you want to get your CV evaluated. But this one is not self-petition. This one does require employer sponsorship. And so your employer is going to have an interest in making sure that before they spend the time and maybe even the money, although they're not required to pay for it, some will, before they're going to do that, they're going to want to make sure that they get someone to evaluate it, whether it's someone in-house or outside counsel, to look at it and say, okay, if we file this, then what are the chances that it's going to be successful? And I mean, charter, for example, why would you, as the person who's going to represent the university in your office, why would you want to make sure that, I don't just file every single professor or researcher petition that comes before us?
Well, there's a few different reasons. There may be a quicker route that already exists. I mean, we talked about the special handling process. So if we have a new faculty hire and we've got all the evidence right there that we did all the postings like we were supposed to, there is no reason in the world we should ignore the fact that we've got a special handling route, unless there are some extenuating circumstances. And I know we haven't touched on it, but typically, citizens or someone who was born in China, mainland China, or someone who was born in India will be often in a backlog category for the EB2. Yeah. So sometimes with them, we might start looking like, hey, do we have the ability to go EB1? But the main reason for it is we also don't like filing weak cases. If there's a limited chance or even a significant chance that the case could be rejected, it doesn't. Sometimes the individual faculty member says, well, I just want to try, and like, I'm willing to pay for everything. And it's like, yeah, but it's the University of Alabama whose name is on the petition. And so even though we may not be paying for all of the filing fees, if the University of Alabama gets a reputation for filing frivolous cases, all of a sudden USCIS and those dozen plus adjudicators that review these cases down in Texas are going to start looking at everything that comes across their desk from the University of Alabama and really critiquing it, because we have a reputation for filing bad cases. So far, we've had no cases denied, but that's because I think we do a good job, and Carol and her firm does an excellent job of vetting things in advance. And if we feel like a case is maybe on the border, we might say, hey, here's what we need to build up this case up to make it a very solid case. It might take an extra 6 months or another year to get a few more things documented, but we would rather have it be very well documented and almost guaranteed approval, rather than filing something that right now is a potential denial. It's not to say that we haven't been denied, but I know we've gotten RFEs, we've gotten requests for evidence, which is the equivalent of an audit of our case. And those are sometimes more work than the original case. And I don't want that to fall on Carol's firm or the department who's sponsoring somebody either, because that's a lot of work. So anyway, I've had to be the bearer of bad news to say, well, the University of Alabama is not willing to move forward with this right now. we might be in the future, but at, you know, at this moment, this is what we need to do to get this ready. So that's why we're a little bit more cautious. Some employers, you know, they throw caution to the wind, but you know, we want to make sure we have a good track record and that the cases that we file reflect that.
That's a good point, Charter, about India and China. We don't have time today to get into all the intricacies of the different preference categories of employment-based processing for permanent residency, but suffice it to say that when you get to the point where you're looking at permanent employment-based permanent residency options, if you were born in mainland China or India, then you're going to have more obstacles related to timing. There are backlogs for those two countries, and you know, most all of the categories, the preference categories, except for some of these higher preferences, like this outstanding professor or researcher or an extraordinary ability case. Even the national interest waiver, although it is a self-petition, it is still a second preference, an employment-based second preference, which means there's still a backlog for India and China. So it's just, you know, sometimes if that's your only option, that's what you've got to do. But that's why it's really important to, you know, to seek some advice, to, you know, don't rely on your listservs and your Google searches. Just, you know, just that. I mean, get some in-depth research, talk to a professional, and make sure that you understand what your options are, because all of those can be impacted by what your job is, what country you were born in, what country your spouse was born in, if you have a spouse. You know, all of those things can be really important, and it's going to take someone who's a professional in the field to really understand what, you know, what option is going to work best for you. We spent a lot of time talking about employment-based options for temporary and permanent residency, but I wanted to point out just a couple of other things. If you'll do the next slide, Charter. There are some family relationships that can result in, you know, a path to permanent residency that may be better than going through all of these hoops of employment-based permanent residency. If you are married to a U.S. citizen, and it's a bona fide marital relationship and obviously not entered into for immigration purposes, then, I mean, that's the quickest path for you. It's the easiest path for you. And if, you know, there are some other family-based categories, but now those are going to have these preferences, and there are, depending on which country you're born in, those, you know, those categories could be, you know, the wait times in those categories could be pretty long. So that's something else you could talk to a professional about to see if there are any other options to you. With anything other than marriage to a U.S. citizen or the other immediate relative categories, these family-based categories are going to require that you maintain an underlying, you know, temporary status while you're going through the family-based processing. Marriage to a U.S. citizen does not require that. But again, that's just a unique special category that has a lot of exceptions to the rules for them. And then we talked about quickly the protection categories. You consider if you're, you know, seeking asylum, that's a completely separate type of process. And, you know, if you have questions about that, you may want to seek the help of someone who, you know, regularly files asylum applications. And then, of course, we talked briefly about the U visa, which is for victims of certain types of qualifying criminal activity. There's also the Violence Against Women Act petitions, VAWA petitions, and those are available for men and women. Just so you know, if you've been abused by a U.S. citizen or a U.S. citizen spouse, or even a U.S. citizen step parent, in those situations, you may have, you know, a quicker route or something where you don't have to pursue the employment-based processes. But we've really focused today on the employment-based permanent residency and temporary options, just because, you know, those are probably where most of you are going to be going to find your sponsorship for, you know, continued status in the United States. Last slide.
Yeah, and actually I had one, and there was one question early on about registering for the diversity visa lottery or the green card lottery.
Yes.
And so I wanted to touch on that because I know we're not really covering that. The DV lottery is something, it's its own animal. But the question was, if I register for the lottery, would it cause a problem in the future for applying for a green card? And yeah, so.
Typically, no, because if you are selected in the lottery and you are then eligible to apply for either a visa abroad or application to adjust status here in the United States, there may be some questions about, immigrant intent at that point, but not just with the sole registration.
And I think that that's a good point. Just submitting your name and filling out the diversity visa lottery form itself, that is not an application for a green card. That's just to be considered for the lottery, to be selected for the next stage, which could allow you to file. But if you do get selected, be aware that there are some implications at that stage for applying for your permanent residency, and all the caveats that we had about underlying visa status and everything still apply. So let me advance to the last slide.
And just to note, the diversity visa lottery is not the same thing as the H-1B cap lottery. Those are two different things.
Yeah.
Very different things. Okay, so we've hit on this 100 times during this workshop, maybe more. Don't wait too long. You got to plan early, even for, getting into your OPT, applying for that. You've got to start thinking about that. If you're going to be applying for an H-1B, you probably need to know, is the employer going to be willing to sponsor you? If so, is this a filing that's going to have to go through the CAP selection process? What's going to happen if, what happens in all these processes for your spouse? How's it going to impact your travel? All of those things can get you in really bad situations where, I just had a case for a client in Mississippi who, just didn't apply for OPT and was assuming that she'd just, apply for H-1B when the time came, and she wound up overstaying and wound up having to leave and go consular process for an H-1B. And I think the plane tickets were probably around $10,000+. So that was a very expensive blessing. But, that's why you've got to be working with your advisors. And, like Charter's office is, they're equipped and, able to handle all of the issues that come before, as far as, planning and deadlines and that sort of thing, and what you need to have in hand for travel, for filing for OPT. And they may even be able to direct you, generally with some issues on planning for your spouses. So I encourage you to be sure to contact their office early on. And, if it's a question that they can't answer, they may send you to, to find the answer with an immigration attorney if it's outside the scope of what they do. But just keep in mind that those issues, you have to plan ahead.
And I will second that. And if you do have questions, we always say, we have and I take this moment to just plug, we do have walk-in advising, Monday through Thursday, 11 a.m. to 3 p.m. But be aware, we're all taking turns doing advising. And so you're going to have someone whose expertise is honestly student immigration, not necessarily scholar and faculty and H-1Bs and green cards. So if you have questions about this, book an appointment. We have a link. You'll see it at the bottom of my signature in every email that goes out. You'll see it on our website main page, just below the pictures, where you can book a link and book an appointment. I'm happy to kind of talk to you through that, but it'll be very general because I have to be careful. I'm not an attorney like Carol Armstrong. Carol, you can book an appointment with Carol Armstrong and pay a consultation fee and go through different things and scenarios with her, and she's allowed to give you that legal advice. I can only talk about generalities, like here's some resources for you and here's how it's supposed to work, but I can't necessarily advise on your specific case if it's outside of the scope of our F1 visa sponsorship or our direct H1B or permanent residency sponsorship, because those I am the employer. I can talk to you about that and how we handle that. So, you know, our advising is definitely something where I just want to be careful, you know, not to overstate our advice and what we can give. But if you do need an appointment, you can let me know. I'm also dropping Carol Armstrong's office contact in here, and her firm's website here, so that if you did need to follow up with her about any personal type of filings, whether it's, you know, family-based or individually filing or anything like that, you can. You know, Carol's been a great resource for us and for a lot of institutions and a lot of employers in the area. And I know a lot of folks have used them. So that is kind of my plug. I'm always happy to advise, you know, but I will say each of our staff have different areas of expertise. Like if you come in and you meet with Dwight, our associate director, he, you know, he's great at F1 regs, and he can tell you all about admissions because he comes from an admissions and enrollment background, and he can walk you through those steps. But if you start asking him green card questions when he's on call, he's going to have to just probably refer you over to me anyway. So anyway, if you will, book an appointment with me, and I'm happy to answer that. But it's probably going to be me just referring you to some of the same resources we have here. So, but I'll try to help in any way I can. We did have one more question, and if anybody has any questions, they can drop it in the chat. Which one is easier to apply for, a green card using citations and papers or after finding a job? So kind of like self-filing through NIW or through an employment-based sponsorship through their employer.
Now I got to give that standard lawyer answer. Well, it depends. If it really depends on whether or not you fit into the category for self-petition. You know, is your work indeed going to meet the national interest requirements? And just, you know, citation and papers may not be enough. You got to show that that work is actually has intrinsic merit and national importance. And so that's where the review of your CV comes in by an attorney to look at that and say what, you know, whether or not in that attorney's opinion, you've got a case for self-petition. You don't have a case for self-petition, you don't have other options through family or protection categories, then you may have to go through employer sponsorship. And, you know, I mean, it's every case is unique there, and it really does take an evaluation to look at your CV and see what, you know, what's going to be better or easier from a timing perspective, from a financial perspective, as far as, you know, how much does all of it cost? All of these processes are different. All of them have different overall processing times. All of them have different costs, quite frankly. And then on top of that, you've got other issues that may come into play, like your country of birth and how that impacts the overall processing time and, you know, filing timelines and that sort of thing.
Mm-hmm. And I will say that bit about timing, some of the timings that folks don't think about is the other stuff, right? Like the things like your driver's license, which is a really big deal. You know, some states are pretty easygoing, and they make it real easy for you to apply for an extension of your driver's license with just documentation based on your filing of a case. Like, you know, so in certain states, their DMV may work off of just the receipt notice that you filed and say, okay, some states, they don't need any documentation whatsoever. You know, they may have very different immigration law, and they're just looking at whether or not you have documentation of some kind to prove who you are, more than whether or not you have a valid visa status at the time that you're applying for a driver's license. Alabama is not quite like that. Alabama wants to see a final approval notice. They want to see documentation that you have visa in hand. And this goes back to the Alabama immigration law passed in what, 2010, 2011, and went into effect in around 2012. And that law is extremely restrictive. And it basically says for any state benefits, including attending the University of Alabama, you have to show that you have lawful presence. And evidence of lawful presence is a really difficult thing when the system they use literally is trying to check whether or not that has been approved. So if you're transitioning from an F1 on OPT to H1B and you've got a cap gap extension, and you've kind of fallen into this kind of gray area that's not as easy to advise on. For you, it might not be as hard, but for your spouse or your children, their transition to other visa types like H4 as a dependent, or maybe they're going to be under your green card application, it could pose a real headache for them getting things like their driver's license renewed. So planning early and just realizing there are some things that are truly beyond our control. Our office will work with you as much as we can while you're under our visa sponsorship, of course. But it is the common headache, and every state is different. That's the other big headache, is if you move across the state border to Georgia or to Mississippi, you might have a very different experience going through those processes. So just putting that out there. I did put a link to this AILA lawyer website. Actually, Carol and Armstrong Law, they're members of AILA, which is the National Association of Immigration Attorneys, and Carol's also a member of my national association for international education. So there are sometimes you'll find immigration attorneys who specialize more in the academic realms. They belong to associations that our institution also belongs to. I bring that up only because somebody asked about immigrating to Canada for work. Completely different immigration system, different process for work visas and green cards, or the equivalent of the green card in Canada. And so you would have to work with your employers there. But there are sometimes immigration attorneys based in the US that are also based in Canada, and their specialization is working with the transition of Canadian employees to the US and US employees to Canada, and can also advise on that. So that website may allow you to kind of find some possible law firms that are part of AILA, or attorneys who are part of AILA that may be able to advise on that.
Do we have any other questions? I
didn't see anything else other than that citation question about whether or not it's better to go through the NIW route or through the employer route. Sometimes it's whatever gets you there quicker. I know that Carol, one of the things that I've always appreciated about your firm is you take a holistic approach, and when you're advising our faculty and staff that we're sponsoring, you're looking at everything and ultimately trying to get them there as quickly as possible. They may not think it, but yeah, I know you are. So I've always appreciated it.
Well, I appreciate everyone attending today, and I hope that some of the information that we've given you is helpful. I know that Charter and the rest of them have given y'all some good links to various information, so that you can, you can go and do some independent reading. And, if you have additional questions afterward, Charter, I think you said you were going to put this up, the recording up as well, so that everybody will have an opportunity to go back in and listen again if you need to do so. And I want to thank Tanya's office and Dwight as well for you guys being available and on our workshop today and helping us out. Tanya, do you have anything else you want to plug for your office?
No, just, if there's anything we can do to help you, please stop by. If I don't know the answer, I will happily send you over to Charter.
And I'll happily accept you. Thank you, Tanya.
Well, thanks everyone. And I hope you have a great rest of your day, and we'll look forward to speaking with you again soon.